Thank you very much. We now come to the 10-minute rule motion. Neale Hanvey.
Thank you, Madam Deputy Speaker. I beg to move that leave be given to bring in a bill to amend the Scotland Act 1998 to transfer the power to legislate for a Scottish independence referendum to the Scottish Parliament, to provide that such power may only be exercised where the Scottish public had demonstrated its support for holding such a referendum, to provide that no such referendum may be held sooner than 7 years following any previous such referendum, and for connected purposes. I'm standing up for the right for self-determination. I'm standing up for our territory. I'm standing up for our people. I'm standing up for international law. I'm standing up for all those territories, those small territories and peoples the world over. These are the words of then Prime Minister Margaret Thatcher, recounted from her Downing Street years memoirs. She goes on to say, the principle of self-determination has become a fundamental component of international law and is enshrined in the UN Charter. And that principle she spoke of, the principle of self-determination of peoples, was enshrined in the UN Charter when Prime Minister Winston Churchill signed the 1941 Atlantic Charter. Any notion that Scots freely entered into the Union by an act of self-determination has no credibility whatsoever. In 1707, a majority of Scottish parliamentarians may have been persuaded, but the people were never consulted. The Acts of Union 1707 between England and Scotland created the Kingdom of Great Britain, establishing a single political entity, yet preserving the territorial, legal and institutional integrity of each partner country. The UK's constitution is not codified in a single document, so the question of whether the Acts of Union can be unilaterally dissolved by one party is not clear. However, the accepted position hitherto is that the Union is a voluntary association of equal partners and that Scotland has an unquestioned right of self-determination. Scotland's distinct constitutional tradition is best expressed by Lord Cooper in the case of McCormack versus Lord Advocate, which says the principle of the unlimited sovereignty of Parliament is a distinctively English principle which has no counterpart in Scottish constitutional law. And in the pleadings of the Honourable and Learned Member for Edinburgh South West in her prorogation case to the UK Supreme Court, it was noted that the 1707 parliamentary union between England and Scotland may have created a new state, but it did not create one nation. In recent years, the UK state has steadfastly refused to acknowledge or honour the principle or the democratic wishes of the Scottish electorate. According to distinguished academic and legal practitioner in international law, Professor Robert McCorquodale, the people of Scotland are distinct within the UK and have a right to self-determination. And as the people of Scotland are a people for the purposes of the right to self-determination, the choice of the means to exercise it is for the people to decide, not for the state. These are not obscure or arcane points of law, they are precise and purposeful, and according to Professor McCorquodale, such treaty obligations are binding under international law on all states. The question of whether the ancient nation of Scotland should be an independent country once again continues to be the subject of much debate. In short, with current support sitting at 50% across the population and above 70% among younger people, the matter is far from settled. It is entirely proper for any country to review such important matters because Scotland will only become independent as and when a majority of the people of Scotland choose that path. This demands the use of a democratic mechanism that is constitutional and satisfies international legal precedent. This bill seeks to standardise and codify such a requirement in line with the motion passed by this House, which endorsed the principles of the 1989 Claim of Right and which acknowledged the sovereign right of the Scottish people to determine the form of government best suited to their needs. At that time, the Claim of Right was supported by every political party save the Tories. In particular, Liberal Democrat MPs such as Ray Mitchie and Charles Kennedy were forthright in their support for the principle of Scottish sovereignty. They were following a Home Rule tradition in that party, which never for a second disputed Scotland's right of self-determination, albeit they thought Scotland should choose a form of federalism rather than independence. It would be unfortunate then today If already having deserted their historic commitment to the European cause, the Liberal Democrats were to follow that by deserting their historic commitment to respecting Scotland's national rights. This morning, the Honourable Member for Edinburgh West called this bill, which favours neither one side nor the other, divisive and unnecessary, when it is anything but. It is in fact both liberal and fundamentally democratic. The effect of this bill should be uncontroversial for every member. It merely establishes in law an equivalent mechanism to the principle already conceded by the UK Government in relation to a border poll in Northern Ireland. Firstly, that the power to legislate for a referendum requires a democratic mandate from the Scottish public to do so. Since 2014, that criterion has been met in successive general elections to the Scottish Parliament, most recently in 2021, where a majority of MSPs were elected and a majority of votes were cast in favour of a manifesto commitment to deliver an independence referendum. Secondly, this bill states that no such referendum may be held any sooner than every 7 years after any previous such referendum. Should members of this chamber deny Scotland her legitimate claim on self-determination, then it will have put beyond doubt that the voice of the people of Scotland is not welcome in this place, and a new approach must be considered. This bill offers both remedy and route. It places the power to decide firmly where it belongs, in the hands of the people of Scotland, and it does so by transferring the power to hold a referendum on independence to the Scottish Parliament. It is a parallel initiative to that being led by my Alba Party colleague Ash Regan MSP in the Scottish Parliament. Ms Regan has brought forward a draft bill that would allow a referendum to be held to ask the people of Scotland if they think that the Scottish Parliament should have the powers to negotiate and legislate for independence. Its purpose is to consult the people of Scotland on their opinion on extending the provisions of their Parliament to hold such a referendum, a proposition supported by expert legal opinion of Aidan O'Neill KC. Both proposals have at their heart the democratic imperative that Scotland's political destiny must be in the hands of the people of Scotland, not in the hands of a Westminster Parliament or the Supreme Court. How does the behaviour of the UK Government or the repeated espoused position of the opposition party constitute access to meaningful political process, as claimed in the recent UK Supreme Court judgment? In the aftermath of the 2014 referendum, the All-Party Smith Commission agreement was signed by all of Scotland's main political parties, SNP, Labour, Tory and Liberal Democrats, and it stated, "It is agreed that nothing in this report prevents Scotland becoming an independent country in the future, should the people of Scotland so choose." While each have failed to deliver on that commitment, this bill provides a necessary, equitable and democratic mechanism for the people of Scotland. In 1889, in this place, the equality of the UK partner countries was asserted by a Liberal MP, William Ewart Gladstone, when he said the following: "I am to suppose a case in which Scotland, unanimously or by a clearly preponderating voice, were to make the demand on the United Parliament to be treated not only on the same principle, but in the same manner as Ireland. I could not deny the title of Scotland to urge such a claim."
Good old Gladstone.
John Major, when Prime Minister, said of Scotland, "No nation could be held irrevocably in a union against its will." It is increasingly apparent that this is not a union of equals. The UK is willfully subverting the will of the people of Scotland by denying them their established human rights as enshrined in the UN Charter and international treaty obligations, which the UK state entered into freely. At the opening of my speech, I cited the words of Lady Thatcher, but she went further. The Scots, being a historic nation with a proud past, have an undoubted right to national self-determination. Should they determine on independence, no English party or politician would stand in their way, however much we might regret their departure. Whether I like it or loathe it, we are in this union, and I hold that it is incumbent on every MP elected on an independence ticket to explore every option with courage and conviction. Today, this chamber faces a choice. Affirm that this is a voluntary union of equals, or tell the world that Scotland is a mere possession to do with as you wish. This bill is a necessary condition for securing Scottish democracy, and I commend it to the House.
Yeah.
I call Christine Jardine to speak for no more than 10 minutes in opposition to the motion.
Thank you, Madam Deputy Speaker. And can I congratulate the honourable member for Kirkcaldy and Cowdenbeath on securing this debate, this motion, but also on his knowledge of Liberal political history. I have to confess, though, that my overwhelming emotion, my overwhelming sentiment on hearing of this debate was, oh, not again. Surely this has been settled not just by the Supreme Court ruling, but the repeated occasions on which the people of Scotland, myself included, other MPs here, the electorates of several constituencies, and the majority of people at the last general election and in the referendum made it clear that no, we cannot be held in a union against our will. But our will is to stay. So here we are. On the anniversary of the parliamentary approval of the Act of Union in 1707, going over the same nationalist argument again and again. The argument which has been rejected in the referendum and rejected at the general election. This could and should be a day when the people of this country might expect their elected representatives to be considering the importance of what has gone before as a result of that act. Considering what we have achieved and what we have built and what we can continue to build and improve upon as part of the Union. Because, as the honourable member said, as a Liberal and a Liberal Democrat, I do fundamentally believe in Home Rule for Scotland. I do fundamentally agree that the United Kingdom needs to change. And I do agree that the people of Scotland deserve incremental increases in power. But that is because I believe in a federal United Kingdom. I have said so on numerous occasions and will continue to do so. I would also point out that in the past 45 years, there have been 3 referendums on Scottish future, Scottish political future, the Scottish people's future, and the state of the Constitution. Every single one of them was facilitated by the United Kingdom government. And on every occasion, the Scottish people have benefited. As a result of the second one, we have devolution. And surely even those devolution sceptics can see the good that has come from our Parliament. The benefits we have seen not just in Scotland, but from devolution in Wales, and the great changes we've seen in Northern Ireland, and let's not forget of devolution to the Assembly in London. The third referendum on independence in 2014 was facilitated by the UK government when they felt that the Scottish Parliament and the Scottish parliamentary elections had proven that there was a mandate. I know this because, and I have a declaration of interest to declare, I worked on that referendum. And as a result, we have more devolved powers. We have come so far since the turn of the new century in devolving powers in this country. So it is closer to the people most affected by it. It would be dreadful to undermine that, to throw the baby out with the bathwater for a separatist argument. And let's be clear, that is what some colleagues want to do. It is not a secret that I disagree fundamentally with my colleagues on the Alba and SNP benches about independence and where Scotland should be heading, particularly at a time when what is required of us in this place is to work together to solve the ills that are blighting people across these isles. And I would repeat, in doing that, the UK government is not a block on more devolution. They have worked to enable it. And whatever nationalists might tell us, independence is not an answer to our problems. It is not even the question that most people in Scotland want to raise. That question is about inflation. about interest rates, about the cost of living. They constantly, in my constituency, ask me about instability across the globe and what we are going to do about those issues. And yes, they want change, but they want a different government. They want a different approach. What they do not want, and what they regularly tell me they are fed up hearing about, is separation. They are tired of the negativity of their world and their children's world becoming smaller because of mismanaged governments and ideological decisions. They want to address the problems with our education system in Scotland, with our NHS in Scotland, with our public services in Scotland, all of which have declined during the period of nationalist government when the only thing they prioritised was independence. And we are suffering, and we do not want to do that anymore. But perhaps if the nationalists lifted their heads from their ideological manifesto about separation, and perhaps if they listened a little more to the people of Scotland and stopped taking the support for granted, they would know that themselves. They would know that they may not like this particular government, and there are times when, frankly, I agree wholeheartedly with the people of Scotland. They don't like this particular government, but they see an opportunity for change coming in the next few months. Perhaps that is why the nationalists are putting new impetus into their cause, because they see that there is an opportunity for change coming, and that people will choose to change the government rather than the constitution. The problem that is before us is that the United Kingdom, we all know, is not perfect. Of course it isn't. What governmental system is? It needs reform. We need to move forward, I believe, to a more federal system. But what we do not need is more division, more rancour, at a time when we already have a list of problems in this country longer than any of us would like. This proposition before us would do little to address those very real problems faced by my constituents and everyone else in Scotland. It would, as I say, be just one more division, more arguments, same old grievances. It's time to move on. Accept that the will of the Scottish people, as expressed regularly, is to remain in the United Kingdom and work to improve it and the lives of all of the people of the United Kingdom. The Scottish people have expressed their will. No, they cannot be, as we have all said, held in a union against our will. But our will is to stay in that United Kingdom. And I would ask this House not to waste any more time on an argument that the Scottish people have settled and will do so again at the next general election.
Question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye. Aye. The contrary, no. Division, clear the lobby. Two minutes now.
There's tellers.
Yes. If they're not putting in tellers, the division's off.
Yeah, they're over there.
Question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye.
Aye.
Contrary, no. No. Tellers for the ayes, Jonathan Edwards and Carol Monaghan. Tellers for the noes, William Ragg and Sir Robert Buckner. Lock the doors. Order.
The ayes to the right, 48. The noes to the left, 228.
Thank you. The ayes to the right, 48. The noes to the left, 228. So the noes have it, the noes have it. Unlock. Order. The clerk will now proceed to read the orders of the day.
Safety of Rwanda, asylum and immigration.